Good morning.
Liz?
Good morning,
Hi.
Liz.
Morning,
Hi,
Liz.
good morning,
Morning.
Megan.
Good
Early morning,
morning.
early Monday morning.
Morning, Cal.
Morning, Jim.
Hi, Cal.
Hi, Liz. Everybody's here, it looks like. Huh.
Does.
Yeah. Carla, are you back from your trip?
I got back last night. Yep.
Oh my gosh.
Yeah,
Oh,
wide
sh-
awake. 3
Wide
this
awake.
morning, wide awake. Ready to go.
What's the
Wow.
time difference?
I'm sorry, Liz.
What was that time difference that you had to get back from?
Well, I'll tell you. My world clock says it is in Amsterdam.
What, 7 hours?
3:59, 4 in the afternoon.
Oh my gosh.
Mhm.
You'll be ready for a glass of wine here in no time.
Yeah, about noon, yeah.
Oh my gosh. Well, I hope it was a great trip, Carla.
Yeah, I said it was a historic time to be in Finland and Sweden.
Oh my
Yeah.
gosh.
We were in Helsinki, which of course is 100 miles from the Russian border, and it was just a really interesting time to be there. I'm really glad we did it.
Oh my gosh, that must have been something.
It really was. Saw numerous, forests and mills, and met with the Minister of Forestry and Agriculture.
Mhm.
It was just a great tour. The Dean of the College of Forestry at OSU organizes it, and we just saw a tremendous amount in 10 days.
Wow,
Mhm.
amazing.
Yeah. We did that 3 years ago and went to New Zealand, and then you come back and it just gives you, kind of a different perspective on, you keep looking at your own situation, and it's just good to get out and see what others are doing.
Yeah.
Mhm.
One of these days we're gonna have to talk. I did a report with women in forestry in Finland and Sweden and Norway and
Uh-huh.
Germany back in the 2000s for a subcommittee for the UN when I was in DC. We got to talk about the women. It was pretty amazing.
It is amazing how many of them are in leadership positions now and
Mhm.
in forest ownership. Mhm.
Yeah, because back then, because of progenitor laws in Europe, it was mainly guys. And
Yeah.
so that we were at a pivot point back in 2004.
Mhm.
So, I'd love to hear how things have changed.
This guy has got to interrupt since it is time to start a meeting. Sorry. All right. Welcome, everyone, to the Monday, May 16th Board of Forestry virtual special meeting. For the record, I'm Jim Kelly, Chair of the State Board of Forestry. Today, we are live streaming this event on YouTube, and all participants are joining this meeting virtually. To ensure our viewers online can follow along with our proceedings, I'll go over some meeting housekeeping items. Everyone participating, please silence your cell phones and try to limit any background noises. Remember to mute yourself when you are not speaking and disable your video when not presenting or part of the discussion. For the record, we ask all board members, department staff, and invited guests to state their names for those listening online. If you experience online technical issues, use the chat function on Zoom to connect with our ODF host during this meeting. For those viewing this meeting via live stream, I'll remind everyone of our general order of operations. After an item is introduced, I'll invite the presenters to begin. For board members, if you have clarifying questions, please use the raise hand function in Zoom, or if present, merely raise your hand and I'll call on you. Presenters, we will do our best to ask questions one at a time. After presentation, we will open the floor for discussion and additional questions. We offer real-time public testimony under item 4, where the public can comment on emergency fire funding legislative concept decision. At the end of the staff presentation and board questions, I will invite members of the public who have signed up for the item to join us either online or by phone. Board members can ask follow-up questions from the presenters before the board sets forth a motion for discussion and vote. We will use a roundtable approach for the voting process, which seems to work best in the virtual public meeting environment. Additionally, members of the public, we ask that if you would like to submit written testimony for agenda item number 4, please send in your comments by May 30th. Lastly, please note pursuant to ORS 192.660.2 the board will meet in closed executive session starting at 7:55 a.m. The purpose of the session will be to consider information or records that are exempt by law from public inspection. Representatives of the news media and designated staff shall be allowed to attend the executive session. This session is otherwise closed to the public. We will take a break before the virtual executive session begins and another short break to give the board an opportunity to re-enter the public portion of the meeting. With that, any questions? Hearing none, I will perform a roll call to confirm quorum can be met for today's items. Liz, go on.
Chair Kelly, Liz Ekpala is present.
Carla Chambers,
Carla Chambers present.
Ben Doimling,
Here.
Chandra Ferrari,
Here.
Joe Justice,
I'm here.
Brenda McComb,
Here.
and I'm here obviously as well. All right, moving to item 1, State Forester and Board Chair comments and board. Welcome, State Forester Cal Mukamoto. Please offer your opening comments.
Thank you, Chair Kelly. Oh, wait a minute, I gotta unmute myself. Am I unmuted? Okay. Thank you, Chair Kelly. And good morning, everyone. I know this is far earlier than our usual meetings, but I appreciate you making the time this morning for this special meeting. I wanted to note that May is typically one of the few months of the year that the board doesn't typically convene. But here we are at our second special board meeting of the month. And I think this underscores just how much important work the board has on its plate. It takes quite a bit of logistics to make these meetings happen. So I wanted to thank the ODF staff involved for all the work they put in over the past few weeks on back-to-back special meetings. The legislative concepts you'll be hearing about and deciding upon this morning are vitally important to the department's long-term financial stability and operational stability. Having an adequate source of available funding to cover fire season costs is one of the most critical and pressing issues facing the department today, if not the most pressing issue. Not only does the current emergency fire funding structure introduce additional and unnecessary challenges, uncertainties, and stresses into ODF's wildfire suppression work, but the costs we cover and debt we carry year after year jeopardizes our ability to successfully accomplish all our other core businesses. While typically not as high profile as firefighting, the other work we do is equally important, as important to fulfilling our mission of protecting Oregon's forested lands from numerous threats they face. We owe it to Oregonians we serve to do all we can to address this issue so we can focus on our mission in its entirety. So thanks again for coming so early, and thank you for this time this morning, Chair Kelly.
Okay, thank you, Cal. Boy, we're meeting so often, I don't feel like I have any comments that I need to make at this time. And do want to echo what you say in terms of a big thank you to staff and all the work they do to pull these meetings off. Other than that, any other board comments at this point? Okay, hearing none. We'll go to item 2. Welcome, Mr. Henneman and ODF staff are presenting on item 2. And all right. And before we hear this topic, I want to remind the board that this item is closed to public comment. The board's responsibility is to make the decision based on the record that we have had a chance to review. While the parties to this proceeding have been invited to attend and could answer the board's questions, the board's decision must be based on the record created by the parties in the contested hearing, which limits the scope of any questions they may answer. And go ahead, Nick.
Good morning, Chair Kelly, members of the board, State Forester Mukomoto. I'm Nick Henneman, Interim Deputy Division Chief for the Forest Resources Division, Forest Practices Act and Monitoring Branch. Over the next half hour, we'll present information for your consideration as the board issues a final order regarding notification 2022-531-01917 about the State Forester Comments Hearing request by George Kroll. Civil Penalties Administrator Greg Wagenblast and Department of Justice Attorney Matthew DeVore will walk through the case for us. As a little background, the board has many roles, and often the role is to think about and ask, what if? Those what if questions help develop, inform, and make forestry policy. It is often a broad area that can be covered by the board. Today's task is different as the board needs to issue a final order for a hearing. In this instance, the board is acting as a quasi-judicial body rather than a policy-making body for this part of the agenda today. So the question for this work is, what is, rather than what if? So the questions, those what is questions are, what is the law? And the law is the Oregon revised statutes and the Oregon administrative rules in effect when the operation happened. What is the body of laws that this board has authority to enforce and administer? And those are the forestry laws found in the Oregon revised statutes and the Oregon administrative rules. And then what is outside the board's scope? And other agencies have laws that they administer that might impact and inform how forestry laws are administered. However, those laws are beyond the scope this morning. Then what is the body of facts as it applies to the current law? Those will be discussed in the presentation that lays out the case for your consideration this morning. Then 5, what is the work that's been done for you? Administrative law judges routinely hear cases on behalf of boards to sort through the applicable laws and facts. Then they dispassionately apply the laws to the facts. From this, the judge drafts a proposed order for the board to consider. The board could adopt it as its final order. So the board's responsibility is to consider the record and issue a final order this morning. While the parties may be in attendance, as Chair Kelly discussed, public comment is not really part of this process. The board may ask clarifying questions related only to the already set record, not bringing in new information and arguments. The record contains the relevant laws and facts for the board to consider. In fact, the board's decision is limited to the record. The scope of what can be included in the final order is limited to the state forester's comments as expressed through stewardship foresters on 1, the plan for alternate practices for removing logs out of a small domestic stream, riparian management area, and 2, the statutory written plan required because of a domestic stream. And finally, the board can consider awarding attorney costs and fees. Now, Civil Penalties Administrator Greg Wagenblast and Department of Justice Attorney Matthew DeVore will walk through the case. Thank you.
Good morning, Chair Kelly, board members, and state forester. My name is Greg Wagenblast. I'm the policy analyst and civil penalties administrator, as Nick has stated. I'm going to start the PowerPoint, which I hope everybody can see at this point. And then Matt DeVore will pick up halfway through and cover some of the legal details at the end of it for you. So to get started here, this is about a hearing that was requested on a notification this year. I want to go over some of the rules and the authorities that we have with this. So ORS 527-630, that gives the Board of Forestry states that the Board of Forestry has exclusive authority to develop and enforce statewide and regional rules for implementing the Forest Practices Act. ORS 526-008 states that the board's mission and goals are to be implemented by ODF under the direction of the state forester. ORS 527-670 and OAR 629-605-0170 have the written plan requirements and spell that out for us. And I apologize, I'm going to throw a bunch of rule numbers at you guys, but I want to make sure that you guys understand the background as we get started here. OAR 629-605-170 sub 7 and 8 state that the stewardship forester will notify the operator, landowner, and timber owner of protected resources and that a written plan is required. 527-670 sub 10 states that the state forester is going to review written plans and provide comments, or gives that authority for us. And then OAR 629-605-170, sub 2 and sub 10 are going to be a couple key ones. So sub 2 states that if operation activities are within 100 feet of a type F, which is fish bearing, salmon, steelhead, bull trout, or a type D domestic stream, a written plan would be required by statute. Sub 10 of 0170 says that a non-statutory written plan for activities is required based on ORS 527-670 sub 2. And those would include things like wildlife, aquatic species protection, HL8 or high hazard or high landslide hazard locations, type N streams, spotted owls, removal of beaver dams, that kind of thing. Those do not require, or those are not approved by the state forester. Those we would only provide comments for. And back under sub 2 for the statutory written plans, again, the state forester does not approve those plans. We only provide comments. So those two, statutory and non-statutory written plans, the state forester only provides comments. We do not approve those any longer. Under OAR 629-605-0173, these are plans for alternate practice. These are for waiving or modifying a specific practice under the FPA, and the state forester does approve or deny these plans. We also can provide comments with those approvals or denials, but these are the only plans that we do approve or deny under our authority. OAR 629-605-0170 sub 9 states that statutory written plans are subject to hearing provisions under 527, ORS 527-700 and 527-670 sub 8 through 12. Non-statutory written plans are not subject to contested case hearings. So only statutory written plans are subject to these hearing requests. Under OAR 629-605-0173 sub 3, plans for alternate practices that are associated and part of a statutory written plan are also subject to hearing requests, as this one was. The board authority for decision-making on these on these hearings falls under 527-700 and OAR 629 Division 672. And those are that the board it establishes the hearing request requirements, the hearing process, timelines. They can also submit a request for stay of the operation. And then it outlines the decisions of the Board of Forestry to either affirm, modify, or rescind the comments of the state forester involved with the statutory written plan or a plan for alternate practice that's associated with that statutory written plan. And then it also talks about comments or decisions of the Board of Forestry are not reviewable. So they cannot be appealed farther. What your decision is today will be final with this. And then it also outlines the requirements for awarding reasonable attorney fees and expenses. So with all those rules, and I'm sure you guys were totally taking notes on that, we'll move on to summary of events. So the summary of events for this case are, in the fall of 2021, Stimson Lumber started planning for the Nordgren HL unit to be a 2002 operation. And at that time, when they started the planning efforts, they contacted ODF. The operation area was to be a clear cut overstory removal on 59 acres. And as part of that, a pre-operation review was completed by the local ODF stewardship forester and one of our ODF geotech specialists. Our ODF geotech specialist provided a review of the planned area under the parameters of OAR 629, Division 623. Whoops, sorry. And then Stimson did file a notification then following all that for the harvest operation on January 26, 2022. Stimson also filed a non-statutory written plan dated January 25th, 2022 that addressed the January geotechnical report and high landslide hazard locations. So based on those reviews, in the pre-op, they filed that non-statutory written plan. ODF's initial review of the notification by our local stewardship forester provided showed on the ODF resource data that streams within the operation were non-fish bearing and non-domestic use. On February 15th of 2022, Mr. Kroll alerted ODF of chainsaws in the operation area up on the hillside and provided information on a domestic water intake on Spring Branch Creek. At that time, timber falling along Spring Branch Creek had already begun on the small, at that time, type N stream. On February 18th, 2022, ODF asked the Oregon Water Resources Department to double check the correct location of the registered water right, as those water rights are provided to the department by the Oregon Water Resources Department. On March 2nd, Stimson Lumber submitted a statutory written plan for protection of the stream as a type D domestic, as well as a plan for an alternate practice prior to the final decision of Oregon Water Resources Department and ODF classification change. With those written plans, there are public comment periods, so they started that process early. On March 16th, 2022, Mr. Kroll submitted 2 separate comments on the statutory written plan and on the plan for alternate practice that were submitted by Stimson. Also on March 16th, 2022, Mr. Lund, the property owner with the water intake, submitted comments on the statutory written plan and plan for alternate practice as well. On March 23rd, 2022, Oregon Water Resources Department notified ODF of their decision for water diversion location on Spring Branch Creek, resulting in the reclassification of Spring Branch Creek to a small domestic use stream, requiring a written plan pursuant to ORS 527-670 sub 3. On March 23rd, 2022, state forester comments were provided on the statutory written plan and approval with comments of the plan for alternate practice, as that was the final day that the state forester could provide those for the timeline. On April 1st, 2022, Mr. Kroll filed a hearing request per ORS 527-700 sub 3, 4, 5, and 5. and also under OAR 629-672-0210. On April 4th, 2022, the request was determined to meet the requirements of the hearing request per those rule sets. On April 15th, 2022 and April 21st of 2022, a two-day hearing was held by Administrative Law Judge Triana with Mr. Kroll, Stimson Lumber, Bighorn Logging, and ODF, along with Department of Justice Assistant Attorney General Matt DeVore. On April 28th, 2022, Administrative Law Judge Triana issued the proposed orders with the record of the hearing and instructions and a timeline for filing exceptions with that notice. On May 5th, 2022, the exception period was closed. Oops, I guess I need to keep up. There we go. So with that, I'm going to turn it over to Matt DeVore, who will continue on with providing you guys the rest of this information.
Good morning. Thank you, Greg. Chair Kelly, members of the board, can you hear me okay?
Yes. Great,
thank you. So the burden of proof, thank you, Greg, for running the slides. In contested cases, further introduce myself, Matt DeVore from the Department of Justice, provide general counsel advice to the Department of Forestry's Private Forest Division and represented the department in this contested case. So getting to the burden of proof, in contested cases, the party that is asserting a position or an argument bears the burden to present evidence that are persuasive enough to prove by a preponderance of the evidence that his or her position should prevail. The preponderance of evidence standard is a fairly low standard. It requires proof that there's more evidence to support that position than there is evidence against that position. And if you put it into numerical standards, it would be similar to just tipping the scales over 50%. It's 50% or more likely that they have the evidence to support their position, as opposed to a contrary position or not being able to prove that position. In this case, the ALJ determined that Mr. Kroll bore the burden to prove that the stewardship forester's comments on behalf of the state forester should be modified or rescinded. And the department's position was that the stewardship forester's comments should remain affirmed as they were drafted. In the administrative law judge's proposed order, she set forth two primary conclusions of law. And I'm sorry, Greg, if we could go back to the last one. Yes, thank you. The two primary conclusions of law, the first one regarding the written comments, the administrative law judge found that that Mr. Kroll did not meet his burden of proof, and that the Board of Forestry should affirm the state forester's comments, which were issued through stewardship forester Eric Jacobs in response to both the statutory written plan and the plan for alternate practice. On the second point, the ALJ found that neither Mr. Kroll nor Bighorn Logging were entitled to an order that either ODF or the other parties should pay for the attorney's fees and costs of any of the other parties. Okay, if we could go to the next slide now. So the administrative law judge's proposed orders, as we've discussed previously, the administrative law judge doesn't have authority to issue a final order. The administrative law judge acts as a fact finder to gather up all the information so that the board can make the final order. So what the administrative law judge has done is issued a proposed order for the board's considerations, and the proposed order goes through the two conclusions of law that we had on the last slide that would affirm the stewardship forester's comments and deny the requests for attorneys' fees and costs. Okay, if we could go now to exceptions. After the administrative law judge issues the proposed order, there's a process for filing exceptions. The exceptions are like an objection to the proposed order. It's not intended to be a forum to relitigate or appeal the proposed order, but instead the exceptions have to be narrowly drafted or narrowly argued to point out either that the proposed order omits or has erroneous or unsupported findings of fact, or that there's a legal conclusion that is necessary but omitted or contrary to law or policy, or that there's been some other prejudicial procedural error in the hearing. Again, it's not a forum to relitigate and re-argue all the same points that we argued in the contested case, but should be narrowly tailored to meet one of those three categories. It gets a little bit harder to tease that apart, because if a party disagrees with the ultimate outcome in a proposed order, then they may believe that the findings of fact that would support their position have been omitted, or they may believe that the legal conclusions are contrary to law. So it does get into a gray area of how much they can try to relitigate the issues with the exceptions. But in general, it's not meant to be an opportunity to relitigate or re-argue what had already been decided by the administrative law judge. If exceptions are filed, they must specify the disputed finding, opinion, or conclusion with which they disagree. They must also include the nature of the error and any alternative or corrective language that should be adopted by the board in order to fix that problem in the proposed order. Greg, if we can move on to the next one, please. Thank you. In this case, Mr. Krall did file exceptions on May 5th within the timeline set out in the proposed order. And I won't go into a lot of detail here. The exceptions were a part of the board's packet, and there were 4 exceptions summarized here. The first 3 were specific to specific findings in the opinion section of the proposed order. The 4th one related to additional geotechnical review that Mr. Krall felt needed to occur in this case. Before we get onto that one other point I wanted to make is that the exceptions process, it doesn't specifically provide an opportunity for ODF or the other parties to provide written responses. Had there been that specific opportunity, we would have seen some written responses to Mr. Krall's exceptions. But the way the Administrative Procedures Act is set up, there is no opportunity to respond to the exceptions. Though, as we'll discuss here in a few more slides, the board does have authority through its deliberations to seek further argument from the parties. As long as we don't get into introducing new evidence, the parties can provide the board with argument for why they believe the proposed order should proceed or should not proceed, and to respond to the exceptions should the board have questions. Okay, thank you. If we can move to the next slide. So the matter is before you today for issuing a final order. Hearings under ORS 527.700 subsection 3 for statutory written plans and the plans for alternate practice, or for comments on those plans, provide that the Board of Forestry may either affirm the comments of the state forester, modify the comments, or rescind the comments. And again, these are all comments that were issued through Stewardship Forester on behalf of the state forester. In statute under subsec, and I apologize, it looks like my computer might be trying to restart. So if I drop off, I will try to join by phone as quickly as I can. So subsection 7 provides that the board may issue attorney's fees if a party asserts a position without probable cause, or if a party requests a hearing primarily for a purpose other than to secure appropriate action by the board. And under subsection 9 provides that if the board rescinds or modifies the comments on a written plan, the board may award reasonable attorney's fees and costs against the department in favor of each of the prevailing parties. Also in this statute is subsection 8 that's not discussed on this slide, but it provides a process for a person who is challenging the comments to request a stay to halt the logging operation. The stay request did not come in on this case, and as we've discussed under subsection 7 and 9, the ALJ proposes that attorney's fees and costs should not be awarded to any of the parties. So under 527-700 sub 6, the statute and the legislature have specifically stated that the board's decision in this matter is not reviewable under ORS 183.480. And that statute is part of the Administrative Procedures Act that allows for court review of agency action. And in this case, the legislature has determined that the board's decision is final and not subject to further review. So now we're at the point of what now? The board has two primary issues to resolve, and that's how to handle the stewardship forester's comments, whether to affirm, modify, or rescind those comments. And then the second question is whether to award attorney's fees and costs to Mr. Kroll or Bighorn Logging, which were the two entities that requested attorney's fees and costs. Pursuant to the 527-700 statute, the board has to issue its decision within 45 days of the hearing request, unless the parties agree to an extension. And we are today right up to that 45-day deadline. It's a very tight timeline to bring together the administrative law judge, to bring together three parties and have the department prepare for a contested hearing and a board hearing. So it's unfortunate that we're under such a tight timeline and that we had to bring the board together on such short notice like this, but that is the reason for that urgency is in statute. As Mr. Henneman stated earlier, the board's decision has to be based on the record established by the administrative law judge. That record closed the last day of the hearing. The department and the parties are in attendance, although I did not see Mr. Kroll's name, so I'm not sure that he is in attendance, and I don't know if Bighorn Logging's attorney is present either. I did not see his name on the list, so we may want to check that before the board begins its deliberation. But the parties that are here, Stimson Lumber and Bighorn Logging's representatives, were part of the proceeding when I looked last. And the department obviously is here. We're available to answer any questions of the board. But again, we can't introduce new evidence that wasn't a part of the hearing record. Should the board have any questions of the department or the parties that gets into argument of the facts, I would encourage the Chair Kelly and the board to allow each party an equal opportunity to respond to those questions and to respond to the comments of the other parties. Otherwise, the board's decision really should be based on the record that was established and the pleadings in the contested hearing case.
Matt, Mr. Kroll is with us as well.
Great, thank you. I see Mr. Kroll's name there now. And the other person was Matthew Denley, who is the representative of Bighorn Logging. I saw there was somebody from Bighorn Logging online, but I don't know if their attorney is or if they're hoping that he will be able to attend. But thank you for that. And Greg, that was all that I had. If there's not any other questions, I'll hand it back over.
I think at this time, that is our presentation. So we'll turn it back to you, Chair Kelly, and let the board make the next steps with it. Thank you.
Okay, thank you. So at this point, if any of our board members have a comment or want to make a motion, we are open to that. And I see that Carla is ready.
So a question for Mr. DeFore. You know, in the summary of the case, ODF was key here through our stewardship forester in providing advice saying that a statutory written plan was not required. On what basis would the board consider modifying or rescinding that? Because that seems really core to what happened here and setting this thing off on the wrong pathway right in the very beginning. On what basis would we look at that any differently than that was, you know, a real core pivotal piece to getting this headed in the wrong direction?
Chair Kelly, members of the board, I'll do my best to respond to that initially. What I would say is that when this was first reviewed, when the notification of operation came in, the maps that ODF reviewed did not show a protected resource in the harvest unit. They didn't show a domestic water intake within the harvest unit. So based on that, the stewardship forester responded to the notification saying there's no protected resources. That comment is not subject to review. What happened subsequently to that was that the department learned that there was a domestic water source within the harvest unit. That prompted the statutory written plan. And because some harvesting in the riparian zone had already occurred, that also prompted the requirement of a plan for alternate practice. Once those two plans were filed, then the stewardship forester made comments, which are the subject to this proceeding, and Mr. Kroll provided his written comments on those plans as well. So the focus of the comments were on the statutory written plan and the plan for alternate practice. And I can understand your point that we got off on the wrong foot by saying there was no written plan required. And that's what set about where that's one of the early steps in the course of events.
Yeah.
But what we really have to look at are the stewardship forester's comments on those two written plans.
So a follow-up question. I understand that.
Okay.
And I see where, you know, then Stimson moved forward and really set in motion the correct plans and documentation that was required. It is, you know, being heavily regulated, people really do rely on our judgment. Was that map that we were relying on significantly out of date? What about that map? Why didn't we have that correct information very early on because we provided wrong information?
The department relies on, it collaborates with other agencies, with ODFW and Oregon Water Resources Department to identify the protected resources. And in this case, the map that we received from Water Resources did not have the domestic intake located in the right spot. And I don't know that the hearing got into a lot of details as to why that domestic source was not correctly identified on the Water Resources map. But the map layer that we received from Water Resources didn't have the right location. As soon as the department realized that it was not in the right location, there were extensive communications between ODF and OWRD to get it corrected. But as soon as the stewardship forester learned of the error on the ground, with, you know, visually seeing where the domestic water source and visually seeing that it was within the harvest unit, he contacted Stimson Logging, and Stimson within hours stopped their harvesting to you know, figure out where the error was and to not do any further work within that riparian zone. But the department did rely on Water Resources and just had the wrong information. And I don't don't believe that our evidence went into a whole lot of detail as to where the miscommunication was that led to the incorrect placement on water resources maps.
Just to add to that, you know, the agency does not regulate the water rights, and so we rely on water resources to provide us. They're the ones that designate those and map those. And so the ODF relies on water resources to provide us that data, and we go based on what that data is. And for this situation, they actually had some really old maps, and the location based on the maps that they were provided in their records created some confusion as to the location. And so they had it mapped in a different, on one of the other side tributaries, streams, than what it actually was. And so that's where that communication between our field staff on the district and water resources, the water master, did some further investigation to try and sort that out and determine if it was the water intake was in the registered location or not. And then basically once water resources gives us the intake locations and stuff, then we can classify the streams as a domestic stream or not. But it's all based on what information water resources provides to the Department of Forestry.
Okay, thank you. Chandra Ferrari and then Brenda.
Yeah, thanks. For the record, Chandra Ferrari. I guess my question is along similar lines in terms of consistency of practice and making sure that we're applying or implementing our practice consistently amongst all the different operators. And I'm wondering about when you have, like, I understand that you rely on water resources for information on water rights. That information is not always up to date. We know that. And I seem to sense some information in the record that there were notifications along the way from these landowners saying, hey, we think you got this wrong, and then maybe subsequently there was some follow-up. And I'm just wondering, was there ever a conversation about delaying, right, the operation while these things were sorted out? Or when does something get to the level that you decide I need to follow up on this and make sure this information that we're relying on is accurate? Because it seems like you rely on water resources, but at the same time, you also, acknowledge when, folks are coming to you and saying this is wrong. So where's that line? And do we apply that consistently? And then do we also delay operations sometimes while we try to sort that out?
And thank you, Chair Kelly and members of the board. I'll again take an initial shot at responding to this. The record shows that when the stewardship forester heard from the landowners that the domestic water source was within the harvest unit, it was a matter of days for the stewardship forester to go out, get boots on the ground, and to visually observe where the domestic water source was. As soon as he saw that, it was then a matter of hours before that was communicated to Stimson Logging, who stopped operations in that area. And I would, for the sake of responding to the department's authority, if the department doesn't know that there is a protected resource and the department just hears information that there may be a protected resource there, the department wouldn't necessarily have the authority to go out and stop the operation. There really does have to be some evidence, either from a sister agency or from visual observation, before the department would have authority to force the operator to stop. So what happened here is that the department learned of the possible error within a few days, investigated the error, and then as soon as they confirmed the location, there was a pause on the operation and ultimately a stop on the operations within that riparian zone. So I can speak to that for this specific case, but as far as ODF's practices in general and how it investigates new information like that, that was beyond the scope of this hearing, and certainly something that I think the department would be very interested in discussing more outside of the context of this hearing.
might add a little bit to that is the department has layers, GIS layers that inform the work that the stewardship foresters do on the ground. And one of those is the Water Resources Department map. So the decisions need to be based on that. And with better information, the department was able to take a different course.
Okay, Brenda?
Thank you, Chair Kelly. Brenda McComb for the record. I had a question about in line with Chandra's, and that is consistency in approvals and recommendations. And in the alternative plan, the down trees and deadwood, the fallen trees in the riparian area were to be removed. And it says that they would be removed to facilitate the restoration of that area, increase reforestation and planting efforts, seed mulch this exposed soil. And then further down, it talks about wood loading to debris torn events that might occur. And so my question is removal of down and dead wood from riparian areas a consistent recommendation by forest practices foresters when advising landowners or approving plans?
Chair Kelly, members of the board, and I'll again take a first stab at answering this. The record in this contested hearing did not get into a lot of detail of how such a situation is handled in other areas. I think it's fair to say that the testimony of the ODF geotechnical and stewardship forester could be interpreted to say that this isn't a common event, so it was not something that they've commonly had to provide input on. There is a tech note that addresses this in a couple of sentences that talks about how there have been studies that have gone either way as to whether it would be best to remove those trees and deadwoods in situations like this. The ODF geotech specialist testified that in this situation, it was what they discussed between the stewardship forester and the geotech specialist. They believed that removal of those trees would be the best practice in this situation, based on their review of the studies and the scientific background and the specific facts of this case. And then how that is handled in other situations in other areas, we did not get into any detail.
Brenda McComb for the record, just a quick follow-up. Thank you, Matt, for that. Yes, I understand that each decision is based upon the circumstances surrounding that specific case. I guess my question is, are the recommendations here an outlier compared to what other recommendations would have been made in similar situations?
Thank you, Chair Kelly and members of the board. My response to that would be that there were not other situations that were raised that were similar to that, similar to the fact situation. We didn't get into any of those that these folks had to make judgment calls on in other areas.
Okay, thank you.
Yeah, not to say that it hasn't happened and it may have come up in other situations that ODF I'm sure would be happy to discuss, but for this contested case, I don't know that we got into that detail.
Thank you.
Are there other board comments at this time? So hearing none, I'll make a few comments on this. Clearly an error was made somewhere. Obviously, the situation is somewhat murky, but at the same time, so we have parties who have been inconvenienced at minimum. And this has cost people money for the whole process that we're going through. I hate to think of how much the taxpayers are paying. in this whole process. So, you know, and it's kind of typical of a lot of legal process. The only people who remain whole typically are the attorneys who get paid one way or another. And it's very, very common for everybody else to take their lumps and get hurt, which to some degree, which, you know, all my years of business, that's why I avoided courtrooms and legal proceedings to the greatest of my ability, because rarely does it kind of work in a way that it magically should, and that there's clear right and wrong, and that everybody is made whole. So you know, from my point of view here, it's quite a leap to have some mistake made somewhere to parties requesting that they would receive attorney's fees. To me, that's a huge leap. Not denying that this has been a good situation for any of the parties involved, but as I look at this record and look at the judgment that's been made, it'll be my view that we should affirm that. Open to other points of view, and also open to someone presenting a motion here. Carla.
Just offering a different point of view, Jim, you know, I would correlate this to lien law with and how much we rely on Secretary of State's office to have their records up to date and correct. And it's not a little bit of liability or exposure, it's a lot if we don't identify lien holders and we are in the same situation. We really rely on those state agencies having correct information. In this case, it was just really incorrect information that set this whole thing off, out-of-date maps that set this whole thing off, and you know, really created a tense, poor situation. So there is damage. There can be substantial liability in situations like this, and you know, I think that's what it's just important that we recognize, you know, how these cascades get started.
I recognize that, Carla. You know, my main point here is that I think of all the times, even with government, and I'm sure this, in your case too, having run your business, that you have dealt with a agency that has made a mistake and it has inconvenienced or cost you money directly. Most of us are not able to you know, take that to court and be made completely whole and get attorney's fees. That's an exception, I think, versus the rule of what happens. Because we've all dealt, I mean, tell me that you haven't ever had worked with a government agency that hasn't made a mistake in dealing with you. It happens all the time. It's not good. You know, there is that responsibility for these agencies to do better. And so I'm not trying to excuse it. But again, I find the leap to attorney's fees in this situation to be too big a leap. Other views?
Let me just go back.
Yes, Liz.
Yes, I'm sorry, I just kicked myself out of something. Heck, okay. I guess I do have a question that I thought of as Carla was talking, and that is, who bears the burden of proof? And I don't know if this is in the records. I don't know if I'm asking this outside the record, but who bears the burden of proof to send an updated information on a water intake, domestic water intake, to Oregon's Water Board? Is it the landowner, or how is that typically done? Does anyone know, or is that, or am I asking something outside the record?
Chair Kelly and members of the board, what I could say is that when it comes to mapping domestic water intakes, that is within the jurisdiction and the authority of the Water Resources Department. The Water Resources Department is going to rely on input from their own employees and from the landowners who are using the water intake. Once that is established, they will then update their maps and their GIS layers and provide those to the Department of Forestry. That's about as far as I could go into answering your question.
Okay.
So hopefully that helps.
So Matt, it sounds like there's a dual responsibility when, with the Water Resources Board to map it, and also with the landowner to perhaps ensure that the information is correct. Would I be somewhat correct in that? Okay.
Chair Kelly and members of the board, yes, I think that is correct. It is a dual responsibility, a shared responsibility there.
Okay. Thank you.
Questions? If someone is willing to make a motion here, we'll entertain that. Chandra.
Sorry, for the record, Chandra Ferrari, I was not making the motion. I just wanted to clarify for folks, because I know we've been asking some questions about the water resources process. And just on the order, the ALJ order, I think it's page 8, it does go into a little bit where they think the error occurred. And there's a number of factors in addition to the maps being nearly 100 years old, but a lot of it had to do with the information that was supporting the initial water right permit being off. And then some new modifications, it sounds like, happening to the property, including a new house being built on a separate section. So it does look like there were a couple of compounding factors that might have led to the incorrect designation. So I just wanted to point that out.
Okay, thanks.
Right. It's essentially, as we're saying, these things, when you really dig, they tend to get a little murky. There's rarely a clear and absolute right and wrong. At this point, I'll just remind board members, we have to make a decision. I'm happy to entertain more conversation, but if otherwise, we really have to have a decision made today. So I do need a motion.
Chair Kelly, would you just clarify the legal fees, the summary of the legal fees being asked for here?
That's never,
Or
maybe
is
Matt.
was that information available?
Matt, can you tell us?
The Chair Kelly and members of the board, that the parties did not submit any specific documents as to what their costs were or what they were asking for. But it was Mr. Kroll and Bighorn Logging that both requested that there's attorney's fees and costs be paid. They never detailed what those costs were. And just to be clear, if Mr. Kroll would only be entitled to attorney's fees and costs if the board were to modify or rescind the comments, and Bighorn Logging would only be entitled to fees and costs if the board affirms the comments and then also finds that Mr. Kroll asserted a position without any probable cause or a purpose other than to secure appropriate action by the board. So there do need to be some preliminary findings before even getting to the question of attorney's fees and costs.
Oh, good.
And Darling.
I was going to make a motion, but I see a bunch of other hands up and wanted to not stifle discussion.
Brenda, then Liz, please.
Brenda McComb, for the record, I was going to make a motion as well. So Ben, go ahead. But Liz looks like she may have a
I
question.
have a question.
Yes, go ahead, Liz.
So Matt, this is a question for Matt, what you just said. For Bighorn Logging fees, both requirements are needed in order to move forward with that.
Chair Kelly, board members, if for Bighorn Logging to recover their attorney's fees and expenses under ORS 527.700 sub 7, that's only going to be allowed if the board finds that Mr. Kroll asserted a position without probable cause, or if he requested a hearing primarily for a purpose other than to secure appropriate action by the board. So
Okay.
if the board makes either of those findings, then it would be an option to award Bighorn attorney's fees and costs. And again, we don't know what those costs, we haven't seen any document, we haven't, the process hasn't gotten to the point of submitting that document, so we don't know what those would be.
Thank you, Matt.
You're welcome.
Chair Kelly,
Ben,
this
go ahead.
is Ben Doimling for the record. I guess I just wanted to say I'm sorry to all the parties involved. This is an unfortunate situation. This never should have happened. And I just want to say I'm sorry. But to that end, legally, I feel like the path forward is to approve this, and I make a motion to approve the order as written, I think.
I have a second.
Second, this is McComb.
Thank you, Ben. I appreciate the sentiment, which I will echo of it's a terrible situation. It shouldn't have happened. And I think on behalf of the board and the department, I think it's appropriate to say we're sorry that this has happened. With that, I will, the board has moved to adopt the administrative law judge's proposed order in agenda item 2 and attachment 3 as its final order. So we'll go around with votes on this. So Liz Arpoa.
Chair Kelly, with respect to all the parties, I vote yay.
Carla Chambers.
I have a question on exactly what we're voting on. If we affirm the order, we are not rescinding. Is that correct? I'm just a little bit confused on what we're voting on.
Sorry, it is, we are not rescinding anything. We are affirming what the law judge's proposed order.
Then I vote aye.
All right, thank you. Ben Doimling,
Aye.
Chandra Ferrari,
Aye.
Joe Justice.
Aye.
Brenda McComb,
Aye.
and I am an aye as well. Okay. We have voted to affirm the administrative law judge's proposed order, and we've done that by consensus, so the motion carries. The board will now enter into an executive session pursuant to ORS 192.660, parentheses 2, parentheses F. Representatives of the news media, invited counsel, and designated staff shall be allowed to attend the executive session. All other members of the public are not allowed to join. Board members will leave this meeting to join the executive session and then rejoin the public meeting at 9 a.m. We hope. We may be running a little bit behind schedule. It's 8:07. So thank you, everyone, and try to get into that next meeting within the next 5 minutes. Thank you.
Chandra, did you have a question?
Yeah, sorry, Jen, do you mind just for 1 minute? I just wanted to say that I'm also very sorry about this previous matter that we just decided. And I do want to have a conversation at some point again about the consistency point and about how we do have communications with folks that may have information that counters some of the things that we're getting from our sister agencies, particularly when we're talking about domestic water supply, which I can understand, a lot of these landowners are going to have very particular information and they know their properties. And I just like to make sure that we're applying our process very consistently in those circumstances.
Mhm.
Thank
Yeah,
you.
this is Brenda McComb for the record. Chandra, just to follow up, I also have questions regarding consistency regarding recommendations from stewardship foresters around riparian area management practices.
I agree with that as well.
Okay, with that, we are adjourned and we'll be turning to our executive session. Thank you, everyone. Okay, do we have all board members present?
Yes, Chair Kelly, all board members are present.
Great. Okay, with that, the special meeting of the Oregon Board of Forestry a regular meeting is back in session. And we will move directly to item number 4. And so I want to welcome State Forester Mukomoto and Bill Herber to the virtual meeting table. And I'll turn it over to you, Cal, to begin.
Thank you, Chair Kelly. What we have here today is the legislative concept to deal with our financial issues in dealing with fire. And not to belabor this too much, I'm just going to hand it over to Bill and Mike Shaw, and you guys can bring forward and talk to the board about your legislative concept or our legislative concept. Bill?
Yes, thank you, Cal. Good morning, Chair Kelly, State Forester Mukomoto, members of the board. For the record, I'm Bill Herber, Deputy Director for Administration. Joining me today on this topic is Mike Shaw, Fire Protection Chief, who will be available for any questions. This agenda topic seeks to introduce the board to the department's proposed legislative concepts regarding addressing the funding of emergency fire suppression costs and ensure the department is moving in the desired direction of the board. This is a decision item, and we will be asking for that decision to move our concepts forward into the legislative process. Before we start, I just want to take a minute to remind everyone why we're even discussing these legislative concepts. I think State Forester Mukomoto summed it up well, but I think this graphic is the simplest explanation of why we're here. Currently, the state of Oregon enters fire season with $10 million of available funding through the Oregon Forest Land Protection Fund, which is comprised of landowner revenue in the form of harvest tax, acreage assessments, and lot size surcharges. This mechanism worked fine prior to 2013, when the average gross cost for a fire season was only about $10 million. Since then, the average gross cost of state's fire season suppression efforts have increased dramatically to an average over $80 million a year, with most recently $230 million seasons. However, the funding mechanism has not kept pace with this new reality and has left the Department of Forestry the burden of covering these extraneous costs with internal resources while awaiting cost reimbursements from its partners. With back-to-back extreme fire seasons, this has put severe pressure on the department and its ability to save solvent while maintaining its capability to perform its other core functions. A solution for this problem is paramount for the department to maintain its operational capacity in both its natural resources stewardship and fire suppression missions. With that problem in mind, the department organized an emergency fire funding task force comprised of members from a wide array of backgrounds and with different perspectives in our sector. The goal was for these members to provide input, knowledge, and their experience in addressing two major objectives, and ultimately being able in a place where they can support and help the department champion any proposed legislation. In thinking of solutions, it was critical that the task force keep in mind a couple of key tenets. The first being that the solution had to be sustainable. The department did look at other Western states' efforts on this front, and many were set up without that sustainability mind and ultimately floundered under the weight of the fire reality. In addition, any new solution had to be compatible with the department's long-standing, complete, and coordinated firefighting system. This system is often seen as the finest in the country, and needing to maintain that was important. The two outcomes of the task force was directed to provide recommendations to the department were, one, addressing the state of Oregon's emergency fire suppression funding structure and identifying key elements of a sustainable funding system not reliant on the department's internal resources. And two, there had to be an understanding of the true cost of the state's emergency fires. Any proposal the department puts forward is going to require large amounts of funding for suppression efforts. But as research has shown, the true cost of fire is typically 11 times the amount of suppression. So for the last couple of years, Oregon has lost over $1 billion a year in terms of environmental, smoke and health, tourism impacts, et cetera. Communicating these effects puts the cost of suppression in a very different perspective. As the department worked with the task force, we did identify two distinct components to our endeavor. The first being that the department was already well immersed in covering fire costs and that the situation had to be addressed before moving forward. The second was the need for continual investments into the solution. This goes back to that key tenet of sustainability and the need for a mechanism to keep the solution ongoing. Also, given the variability of fire in each of its seasons, to understand our problem, we had to fall back on what we had, and that was our historical data. So the department's recommendations are ultimately going to be driven by the data we have available. Of course, with data, you often tumble to looking at averages, and with fire, the extreme variability can easily overwhelm a system built on those averages. Last fire season was a perfect example. Prior to 2021 fire season, our average net fire costs were about $40 million. In 21, it's currently estimated at over $69 million in net fire costs. We did look at modeling our future fire seasons, but in working with our economists, we ultimately went to a rolling 3-year average to accommodate our future forecasting. And that's the methodology you'll see throughout the department's data. While not perfect, and still being subject to being overwhelmed, it does give a good balance to reality and being pragmatic about funding asked. Given these components and the recommendations provided by the task force, the department is ultimately proposing 2 legislative concepts to the board today. The first, as I mentioned, is ensuring a solid foundation that would allow us to succeed in the future. This would be through a one-time investment that would cover the costs the department is currently floating, as well as future costs of fire seasons prior to any legislation being in effect. Therefore, the department's first legislative concept is an ask for critical float funding in the amount of $250 million in general fund. This amount was identified through $100 million in debt the department is currently carrying from fire seasons 21 and prior, and additionally using the aforementioned calculation of a 3-year rolling average and taking into account our history for cost recoveries, an additional $150 million that would be needed for the next 3 fire seasons prior to the implementation of a long-term fix, which I'll discuss next. The second legislative concept the department is recommending is the creation of a fund and governance structure to allow ODF ready access to financial resources necessary to cover future emergency wildfire costs. This fund and the committee overseeing it would replace the current structure of the Oregon Forest Land Protection Fund and the Emergency Fire Cost Committee, expanding those current mechanisms to acknowledge the growing participation of public monies in emergency fire suppression. This committee would answer to the Board of Forestry, and its 5 members would be identified and appointed by the board. To ensure this is not an ever-growing fund, there is a cap in place at 2 times the rolling 3-year gross cost average, currently projected roughly around $200 million. Anything above this cap effective at a yearly calculation would be identified by the committee for use in efforts such as fuels mitigation, strategic investments for fire prevention, identification, suppression, and or land resiliency. In order to keep the fund sustainable, the department identified a yearly need for $61 million in revenue to cover ongoing fire costs. Given that the Oregon Forest Land Protection Fund already has a revenue stream built into it, those monies would be diverted into this new fund. Additionally, as those rates have not been increased since 2007, the department proposes an inflationary increase to all the components of those revenues. This would bring in an estimated $15 million into the new fund. On a side note regarding landowner contributions, currently there is a cap on expenditures that landowners could bear within ORS 477, currently at either $10 million or 50% of costs under $10 million. Given that we are trying to address the need for a fixed amount of income revenue or incoming revenue, our recommendations are putting a cap on the amount of revenue the landowners would contribute, a little different than looking at expenditures, but still provides assurances that landowners would not ultimately be responsible for disproportionate share of costs. So back to the revenue in the fund. To date, the general fund has matched those landowner contributions dollar for dollar. So we expect that precedence to continue, which would equate to $30 million a year in existing revenue. For the remaining $31 million needed yearly, the task force and the department looked at many different revenue ideas. Ultimately, the department is proposing that the revenue remaining needs come from the general fund for several reasons. Overall, there is broad acknowledgement that Oregon's wildfires impacts all Oregonians. Even when within ORS 321, crafted in 1967, there was an acknowledgement that the public shares a responsibility in Oregon's fire costs. In fact, most of our neighboring states rely solely on their general fund to accommodate emergency fire suppression. Finally, while looking at some of our possible revenue streams, most that were considered are ultimately part of the general fund feed, and advocating for those diversions seem beyond the scope of the department's responsibilities. For those reasons, the general fund was considered to be the most appropriate revenue source. If we do move these concepts forward, the department will share its funding ideas with policymakers. Additionally, as I mentioned earlier, any fire funding system could be overwhelmed by a severe fire season. As a backstop to proposed legislation, the department would rely on its current pressure relief mechanisms, the emergency board and/or legislative sessions for general fund infusions as needed. And finally, the timeline. Pending the board decision today, the next step would be the final submittal of the department's proposals to the Department of Administrative Services by June 3rd. We would then work with DAS and the governor's office throughout the next couple of months to address any concerns, whereas then DAS would submit any proposed legislative concept to the Legislative Council by July 8th. That's when the department would have the opportunity to work with the legislative branch to finalize the concepts, with the final submittal being from Leg Council to the governor's office by November 16th. And all of that would hopefully coalesce into a pre-session bill in December that would be slated for the 2023 legislative session. With that, that concludes my presentation. And as I mentioned in my opening, the department is looking for the board to approve recommendations for submittal into the legislative process. And Mike and I will be happy to take any questions that you may have. Thank you.
Are there any questions from board members at this point? If not, we'll do public testimony, and then we'll have opportunity there. I see Brenda, you've got a hand up.
Yeah, thanks, Jim. Brenda McComb for the record. Just for clarification, will we have an opportunity to discuss this after we hear from the stakeholders?
Yes, we will.
Yes, thank you.
All right. Do we have anyone signed up to provide testimony today?
Yes, Chair Kelly, we are ready. Oh, sorry. Yes, Chair Kelly, we have 3 individuals who have signed up to provide comments on the agenda, item number 4.
Okay, great. Thank you to those who signed up to provide testimony today. We ask that you not exceed the allotted time of 3 minutes. I ask that before you start, you state your full name and any associated affiliation if you're representing a group or organization. A timer will be provided to track your time, and if you exceed this time, someone will prompt you to provide a closing statement. Okay, Megan, are we ready to go ahead with public comment?
Yes, Chair Kelly. First, we have Mike with Oshawa, and then Heath Curtis with Hampton, and Kyle Williams with OFIC.
Good morning, Chair Kelly, State Forester Bukamoto, and members of the board. My name is Mike Barsotti. I'm a family forest landowners in the Lyons area, past president of the Oregon Small Woodlands Association. I have served on several wildfire-related studies, the most recent being the 2021 Legislative Wildfire Study Technical Advisory Group. I'm here this morning representing Oshawa to summarize the written comments I submitted Friday. We have 2 major concerns with the second of the 2 legislative concepts listed in item 4. We agree that the cap on the Forest Land Protection Fund needs to be higher because of the increase in the number of large wildfires. but we do not agree with using the inflation factor. And second, we don't support doing away with the Oregon Forest Land Protection Fund without first having an established publicly funded large fire suppression account up and running. Regarding the increase of the cap on the Forest Land Protection Fund, simply using the inflation factor will maintain the current inequities in who pays into the fund. Family forest landowners currently pay over 60% of the fund's revenue through the improved lot and minimum lot assessments. Maintaining these current fund source percentages is not appropriate. Suppression of wildfires that threaten homes can be more expensive, but 67% of the funds is too high, especially considering that FEMA has traditionally covered over 75% or more of these funds. And then why should family forest landowners cover over 60% of the funds suppressing large wildfires that don't threaten homes? With regards to our second concern, eliminating the Forest Land Protection Fund, well, I think we all agree that having a public funded account to cover a portion of the cost of suppressing large fires is a great concept, but not all in the legislature does. And therefore, we prefer having this public account established and functioning before merging in the two into a single fund. Having a front-loaded public fund to pay a portion of large fires has several benefits. It is less disruptive to the general fund programs during bad fire years, and it also allows the general fund to cover their share outside of just using general fund dollars. For example, public utilities could be taxed. We all pay for electricity, and I'm sure we're all aware of the impact power lines played in the 2020 Labor Day fires. OSWA suggests you reconvene the task force that has been working on these concepts. We believe that solutions can be found that will achieve the desired goals of the board and ODF, have broad stakeholder support, and will create a fair funding stream to protect Oregon's natural resources from wildfire. I thank you for this opportunity for OSWA to share in its concerns.
Thank you, Mike. Heath?
Chair Kelly, members of the board, for the record, I'm Heath Curtis with Hampton Lumber. A couple comments about this. One, it was pretty hard for those of us on the outside to get information about what was happening here. This was kind of a secret process, and even my own guy at OFIC was reticent to share information with us because he was under strict confidentiality obligations in the process underway. To the degree that the agency and the board support a complete and coordinated process that involved the landowner community, I would suggest that this process has not been it. And you may be a little reticent about supporting these LCs prior to giving everybody kind of the opportunity to see them. The information that was included in the packets was a little cursory. And while I think I've got a general understanding of the structure and concepts, I'm not confident I know what it's going to look like in the going forward. My second comment is that I'm pretty sure that this doesn't actually solve anything. That is to say, the reason we're always stuck in this big mess on fire funding is because the general fund has exposure to these wild swings and volatility. That is to say, the costs associated with fire are very volatile and growing over time. And we've used an insurance fund for some of that, which costs us money. And it's always a question about who's going to pay for that. But here, the agency said, all right, we're going to go get $250 million from the state. We're going to put it in this bank account, and we're going to float the feds out of that $250 million, and we're going to fund fire costs, large fire costs out of that $250 million. But the problem is that you're going to float the feds, and that's going to be in and out money, and you're going to start burning down that $250 million, which is going to result in the exact same thing we've got today. That is to say, a problem where the general fund is exposed. And if the state doesn't pay the 31 million or however much that you've got there, it's gonna create the same political problems going forward. I would propose to you that by that virtue, it's not actually solving any problems for the state. You're putting a bunch of money in a fund That will be spent down to the degree that the state doesn't apportion its 31 million every single year. And the landowners are going to keep paying our money in because it's by virtue of a tax. So from my perspective, it's maybe putting a short-term Band-Aid on the floating the feds question, which will become a problem again. And in exchange for that, we've washed out the landowner voice on the Emergency Fire Cost Committee. We're subject to a big increase in the amount that we're paying. And I don't think most would agree that we're not paying enough already. There's going to be indefinite CPI adjustments. And the way the OLFPF currently works is if it climbs above a certain amount, they start reducing our rates. And that appears to not be included anymore either. So with all of that, we're very reticent about this legislative concept. I think to the degree that the Board of Forestry is being asked to endorse these concepts, I don't think they're solving any problems. They're causing problems for landowners. And I would just be reticent about the nature of your endorsement and the degree to which you rubber stamp this going forward. We have a lot of questions remaining.
Thank you, Heath. Kyle?
Good morning, Chair Kelly, members of the board. For the record, my name is Kyle Williams, Director of Forest Protection for the Oregon Forest and Industries Council. We're a trade association representing timber landowners throughout the state who work incredibly hard to ensure ODF is successful. Because like any partnership, if one fails, we all fail. And it's in that spirit that OFIC engaged with the Emergency Fire Task Force. As is the case in many other states, Oregon's firefighting agency needs the ability to ebb and flow with gross fire costs without compromising its other core functions. And we believe it's prudent business for the state to set aside funds that could be temporarily allocated while awaiting that federal repayment. This is a business process, state lending issue, and not one of revenue. To the extent this conversation continues to be clear about that narrative, we support the concept of LC number 1, which then brings us to LC number 2. I will be frank, there's no safe way for us to have this conversation as landowners. Our system is such that currently there's only 2 ways money comes in, either the general fund or the landowners. The plan was our group would find a new strategy to help share that burden, and we as landowners engaged and had to trust the process, but we didn't get as far as we needed to. The LC asked for raising revenues to over $60 million annually, which is a number we referred to during the process as X. Only after the work group completed, it grew to 61 million. That's a significant change coming outside of the work group meetings and has potential to undermine the credibility of the process. But more importantly, the LC doesn't adequately address the need for an additional source of revenue. I want to be very clear when I say we didn't get where we hoped. Instead, what we created to this point is half a solution that creates a high hazard discussion, potentially leaving landowners greatly exposed to future increases, and at a minimum, creates significant political exposure through a shift of the burden. A couple of additional points I want to raise. Speaking for the large timber landowners of the state, the inflationary increase to our revenue streams was offered as a meaningful and significant way for landowners to share the increased burden. But it comes at a great cost, especially when you consider that landowners only account for 5% of starts and less than 1% of acres burned. The staff report, the inflationary adjustment represents a nearly 40% increase in landowner costs to pay for large fires that impact all Oregonians. Under the right circumstances, we can support this one-time increase, but without determining another revenue stream, attaching rates to CPI in future years, landowners will have no choice but to object. Let's see here. On the idea of abolishing the EFCC, this was discussed in the task force, but was predicated on the idea that an additional revenue stream would be identified. That conversation has now changed. Without new or dedicated funding outside of the existing revenue streams, abolishing the EFCC would be akin to giving away our voice in the conversation. Under the current scenario, we're more likely to support adjusting the current rates, adding a seat for general fund, and leaving the rest of it alone. Oregon's landowners have been expected to step up, and they are. Unfortunately, the rest of the solution is being left up to hope, and that's an uncomfortable place to be. However, we know the need is real. We know more dialogue and improvement is necessary as these LCs move forward, and we remain committed to staying in this conversation in order to improve the outcome for all Oregonians. Our hope is that you as the board will row in the same direction as us and defend the critical role that landowners play in a system we believe is the envy of the Western United States. Thank you for the opportunity to provide this comment.
Thank you, Kyle. Everyone, we appreciate your participation today. You are welcome to remain in the virtual meeting. However, we ask you remain muted and disengage your video unless called upon by the board. Chair Kelly, members of the board, this concludes our public testimony portion for item 4.
All right, thank you, Megan. All right, board members, any questions or comments from what we've just heard at this point? Joe Justice, I see you up first.
Yeah, thanks, Chair Kelly. Joe Justice for the record. You know, I certainly support a sustainable system that really that has a way to preserve our forest products industry. And I think, you know, especially in rural Eastern Oregon, and you know, I at one time before I got on this board, I was the president of the Eastern Oregon Forest Protection Association, and there was an association member, an older association member that would always say, you know, when the woods go quiet, things begin to change. And probably Mike Shaw knows who I'm talking about. And it's going to be having, especially in Eastern Oregon, where we have tremendous threat of losing a fragile infrastructure, a fragile milling infrastructure, a fragile logging infrastructure. As we proceed forward with this into the legislature, we have to make sure that we remind those making these decisions in the legislature that we really truly run a significant risk of tipping this over. We toured in Bend, and we talked to Chris Johnson out on his property outside of Bend at the last board meeting in the field. Great tour. I really appreciate Chris, you know, talking to us, getting, you know, actually seeing what landowners begin to face. And it is, I just cannot emphasize more how the effect of this can be, the unintended consequences of this can be tremendous. And I always go back to that Protection Association member that talks about the woods going quiet. Because when we don't, one of the things we haven't talked about a great deal is that you know, having landowners and their equipment in the field, how critical that is for success of firefighting. It is immensely critical having equipment out there, being able to having ODF, their ability to access that kind of equipment to take quick action on fires, and we can, if we're not careful with all of this, that can change. The other thing is really a landowner voice. I think that. And that's one thing the EFCC gave, and there's a culture of ODF that's very, very strong with the landowners, and we really work together that coordinated system. And I understand it really, really, you know, really well, because I'm a part of that in what I do. And we have to really ensure that landowners continue to have a voice in this, so that we can work together moving forward. You know, I'm prepared to support these LCs, but you know, the continued conversation, how they come forward, we need to continue to talk. Thanks.
Okay, Brenda, you're up next.
Thank you, Jim. Brenda McComb for the record. I'm going to support this because I think it is, as Heath described it, a Band-Aid. It is a step forward to try to resolve a problem that's facing us right now, right here. But it, in my mind, in my opinion, is not the long-term solution to this problem. We want a predictable level of support for all forests outside of the federal boundaries, and hopefully within federal boundaries as too, but in the public and in state forests, or private and state forests, that fires are going to be suppressed and suppressed effectively, and the forest resources will be protected. That's some certainty that landowners would like. But that certainty is becoming increasingly unlikely to be attained. Climate change is going to increase the intensity and size of fires unless we do something different in the way we approach this issue. we need to have a strategy moving forward that strategically suppresses some fires, but allows all of us to learn how to better effectively live with fire in forests. And that can be fuel reductions. That's part of the picture, but that's not the only part of the picture. So I'm hoping that we move forward, get this fire fund solution as a short-term solution moved forward. But I hope we begin to think outside the box about how better to address this issue, because the current structure is unlikely to be effective going forward. Thank you.
Okay, Carla.
Thank you, Chair Kelly. You know, I have been studying the department's budget for some time, and certainly recognize that over 50% of our dollars are going out to large fire. So I very much see the need to segregate large fire out of the ongoing operating funds for this department. So I'm very supportive of that. And the 250 million, you know, does that on the, I think of it as a revolving fund for that core piece. I think that is a pretty essential piece in really shoring up the department's financial stability, is to segregate those costs. I hear loud and clear from the industry, however, that there's not a coalition or support about that $60 million or $61 million sustainable emergency fire fund. And I know we are going to need broad consensus and support from the landowners to make that happen. I also very much believe we need a broader funding, you know, support system to go into that ongoing fire fund. So I support this in concept, but I also realize that this needs some work, because we do need to gain wide base and especially landowner support if we think this has a chance of getting through the legislature.
Okay, thank you, Carla. I'll make a few comments. This is not a perfect solution or set of solutions. On the other hand, I really take exception that this doesn't fix anything, or that it's simply a Band-Aid. If we were able to get the $250 million, that does get us through, you know, the biggest issue we have, which is floating these payments that we wait for from our federal partners. If that is done alone, even that buys us time and puts us in a place where we're not robbing other programs and not being able to make do the work that came out in 762 and all. That would be a big improvement, and hopefully we can get both of these legislative concepts through. But I just to say that this gets us nowhere is it's just far from truth. Also like to make the point that, you know, as we the current situation where really landowners control the fund that they provide half the money for, that's been workable and all, but as we got this idea to have a committee that's appointed by the board, really the idea there is to have that committee represent the folks that are providing the funds. So, you know, some of that representation would continue to be landowners. Some of it would be more oriented towards representing the taxpayers, the money that's coming through the general fund. Just want to remind everyone that you know, the general fund's already paying all of this through these emergency allotments that we get, and day one that what we propose is passed, the taxpayers are benefiting because they're already paying all of that, and they've got $5 million more coming from landowners. So right out of the gate, there's a benefit. And then the only other thing I just want to mention, and that's, you know, the way I have felt about this from day one is that no one, no industry, no group should be able to avoid having to deal with the costs of climate change, and that's what we're really talking about here. And that's why I feel like, you know, industry has to step up, but so do the taxpayers. It's a terrible situation, but I think to expect industry to bear the whole brunt of it, I can't support that. So I think this is reasonably balanced. Obviously, as we've said, the sausage making will happen in the legislature. But I think this is a pretty good package. Any other thoughts or board comments? Brenda?
Yeah, thanks, Jim. Just to clarify, my view is that it does buy us time. I agree with you on that. But I do not think that this is the correct long-term solution to a problem where there is increasing levels of uncertainty due to climate change going forward. We need a more holistic approach.
Fair enough. Carla?
Yeah, and Jim, I think it's just important. I think there's, I think we need additional support and consensus so that we have those landowners really on board with us as we would move into a legislative process. So I think there's understanding about the 250 million, the initial seed money, and that acting as a revolver to really separate that away from our base budget. I think there's, you know, I think there's a lot of support for that. I think people understand that. I do think, however, we're going to need some additional time to have consensus on that secondary piece. So we want the Department of Forestry and the landowners, you know, we will want that consensus going into the legislative process. So I think we need more time. We can possibly hold that 60 million as a placeholder, but I think we would be ill-advised to not bring that consensus with the industry and the Oregon Landowners Association so that there is support and consensus to move this package forward.
I would comment that despite the testimony today, I think there is quite a bit of consensus that's come out of this process, and not complete consensus. And I also, you know, we have a timeline here that we have to hold on to if this is going to go forward. So the concept of to having this the task force continue to meet, as was suggested from the Oregon Small Woodlands Association, that's not really workable. And I would want to say to my fellow board members that OSWA has been a part of that task force, and those issues have been hashed and rehashed, and honestly, I think a lot of effort has been made to bring them into this, and I'm not sure we can fully get there. I hope the department can, as they continue to work on these, can be particularly mindful of their concerns. But I think complete consensus here is unrealistic at this point. Chandra.
Yeah, for the record, Chandra Ferrari. Thanks, Jim, for that. Actually, that was kind of getting to my question, was related to the additional process, because I feel like we need to push something forward to meet timelines. I don't know how baked things need to be at various junctures, because I know changes get made, and clearly at the legislature, there's going to be a lot more dialogue and discussion from all stakeholders in that space. But leading up to these different submission points, it seems like it would be worth continuing dialogue. I don't know if it needs to be in the formal task force, as you suggested. That may not be the right workable venue at this point, because we do have these deadlines, but it certainly does support a legislative process when you've got diverse stakeholders on board going into it. Or I think we risk the success of it once it hits that juncture. So I'd be interested in knowing what the department's plans might be to continue the conversation. And I would agree with what I think both Brenda and Carla said, that, this, I think, goes in the right direction, but clearly I don't think this is going to be the whole shebang solution moving forward. And so those conversations are clearly going to need to happen. So I'm just interested to know what the pathway for some of that is, because it seems like it would be useful to continue to do that.
Great, thank you. I think that's kind of a question here for Bill or Cal.
Yes, thank you, Chair Kelly. This is Cal McMurdo, State Forester. Chandra, I think if we do this, if your board decides to go forward with these legislative concepts, we're going to have dialogue with all stakeholders continuously. And that includes legislators, landowners, and all are going to are affected with this. And I think, initially we're going to have to be able to contact those individuals and have dialogue on this. Beyond that, I'm not sure, Bill, have we planned anything? I know we're already in the middle of planning an information team, but Bill, do you see on the timelines, how we need to react to that?
Yes, State Forester Okamoto, Chair Kelly. Undoubtedly, there's going to be further discussions with our stakeholders. The timeline does put us in a couple of months on each side of the branch, the executive branch, legislative branch. All of those are going to have dialogues with those various decision makers, and then we would engage stakeholders throughout the process. I know Mike Shaw has had numerous conversations with many of the organizations already in play. And we acknowledge a lot of what was said today. When we started this, we did look at a more holistic picture. This is Department of Forestry, but we're far from the only fire suppression entity in the state of Oregon. So a complete holistic picture is going to take those other entities in play, like the state fire marshal. They are running their own legislative concepts given their constraints on funding emergency fire costs. So there is another step to take for a more holistic state of Oregon approach. But certainly for the Department of Forestry, we do have a pathway of further engagement with this. Chair Kelly nailed it on with the timeline. We are kind of behind the 8 ball on moving a lot of these dialogues forward without getting into the process. And that's really the rub, is we have to engage the process by June 3rd, which doesn't allow us to have a lot of these conversations before we kind of put everything out there. But that doesn't mean we can't start somewhere, have conversations, and if it gets too far off the rails, pull it out of either the executive branch or the legislative branch. Just because we start the process doesn't mean we have to finish it if it doesn't seem like we're not getting to the consensus we feel we do need. And we all feel that we do need it. That was the intent with the task force, to get that consensus, to get people to champion and really stand behind a solution. And ultimately, if we get down the road, we have till December to really iron this out. If we feel we're not getting there, it's perfectly acceptable for the department to take some kind of stopgap measure to address some of our immediate needs and work further on future legislation.
Okay, Bill, thank you. That I think that was very helpful for all of our understanding. Do we have any other board comments and or questions? I see that Mr. Justice has his hand up, and then Liz as well.
Thanks, Chair Kelly. Just to summarize all that, I guess this is Joe Justice. I guess what we're saying is the language in LC2 is imperfect. Is that what I'm understanding, Bill? It's an imperfect set of language that potentially, as we walk down the path, could change, or it could be thrown out. Is that what I'm hearing, Bill? Is that what I'm hearing from you?
You're exactly right. Part of the problem is we cannot commit general fund to paying for things before they pay for things. And that is part of the rub. The language that we need to get into our concepts, where we don't have really the ability to do that right now. And certainly that's part of the discussions with the legislative branch, but ultimately that gets us down to the road, which I understand is uncomfortable for a lot of people to take that risk.
Right. No, I appreciate that. I'm prepared to move, because I understand the timeline. I'm prepared to move this forward as long as I understand that this is not perfect, and that there will be more to come on this. The conversation will continue. Thanks.
Liz.
Yes, Liz Powell for the record. So this kind of goes back to being able to keep things in and remove things. Bill, can you just give me some background on why we did a 3-year rolling average versus maybe a 5-year rolling average that would have scooped up 2020? Is that just a question on that?
We actually did look at, so first we looked at truly creating a model to project fire seasons, working with economists and statisticians. The variability on everything was just untenable to really come up with a solution that matched any sense of reality. So then we did start looking at the averages, certainly, but I discussed the pitfalls with those averages. So then we backed into the rolling averages, and we looked at 3, 4, 5, 6 years, and the 3-year model more matched the data we had than anything else, and hence why we landed there. It evened out the extremes on both ends of the equations better than some of the other longer period averaging.
Okay.
And
Thanks, Bill.
Liz, this is Cal Mukamoto, State Forester. I just wanted to add in there, we retained, the pressure relief valves such as e-board and others because of that volatility and the inability. I always say that forecasting is real difficult, especially about the future, and that's kind of the challenge that we have right now with that.
Yeah, you had to pick something. Okay, great. Thank you.
Okay, everybody. Joe.
Sorry, I was muted. Joe Justice for record. Jim, do you need 2 motions? Or are you looking for 2 different motions?
I think we are going to need just one motion, and I was about to ask for it because I only had a piece of toast for breakfast this morning.
Okay, well, I guess I would propose a motion to accept LC1, but I would also, part of my motion would be to accept LC2 as a placeholder that will likely potentially be modified moving forward.
Does anybody else have a problem with that or want to second that?
I think you're
Carla.
muted, Carla.
Chair Kelly, I would like to second that. Joe, I'd like to have a tiny amendment to it. I agree with the 2-part motion of accepting the 250 million in the revolver fund. And then under the 61 million, we know there's a lot of additional discussion, but I would want to take that in the next 30 days right back to the Oregon Landowners Association and really bring them into full discussion and input on really gaining that support. Because we would not want to ask them to give up that association until they supported this.
I'm not really understanding that Oregon Landowners Association.
I'm sorry, I didn't.
OFIC.
OFIC and the current association on, from the landowners. I just think politically, we want all 3 of these entities. We are going to need this support to push this through the legislature. And, we know it's been a task force to date, but we really need to bring the landowners, along to help get this through the legislative process. So I support that 2-part motion with the 61 million, but we have had a lot of discussion on broadening the base and gaining landowner support for that. So I think in the next 30 days, that's really critical to continue those conversations.
Well, I'm going to disagree with that, Carla. having been through all of these conversations, I think the fear that we can't answer and that we won't be able to answer in the next 30 days is the fear that the Oregon Small Woodlands Association and OFIC and other land owners, industry folk, how they feel about what will happen in the legislature and what will happen in that sausage making. And there's nothing we can do today in the next 30 days that is going to fully assuage those fears. We've heard them over and over and over again. I don't see, I just don't see that as, I would love to have us all, at this point more uniformly in line, but I think that's a fool's errand at this point, having co-chaired the process today. Chandra? Yeah.
Yeah, thanks, Chair Kelly. I guess I was just trying to seek some clarity on a two-part motion. And the first with the placeholder, we are with a placeholder, that's just our expectation, right? That dialogue will continue. We're approving the actual concept that we see for submittal by June 3rd. But our understanding, I guess I'm trying to figure out how we're documenting the understanding. And then also Carla's point, it seems like what we're asking for is continued conversation, and if appropriate along the way, modifications as necessary to address things that we're mutually agreeing on. So I'm just, are we capturing that in a motion, or is this just our dialogue and our expectations that we're establishing right now?
I guess I'll just speak up, Jim. I'm sorry. I mean, my intent there is to capture in the motion that it's understood the LC2 as a placeholder that's imperfect. And that's all I'm trying to capture in that motion, Chandra, just for the record.
I agree with you, Joe. I mean, I think capturing that is appropriate, and it's definitely speaks to the process that Bill described that could go in a lot of different directions. I just forcing another 30 days so that we are trying to get these disparate voices all in agreement at this point, that Carla suggested, that's what I don't see as workable. And so I don't have any problem with what you proposed in the motion you made, but that's where I'm sitting. And so Brenda, you have a comment?
Yeah, thanks, Jim. I would propose that we just simplify this whole thing and just say that we accept the proposal as presented, with the expectation that discussions will continue.
Okay, Ben.
I think Brenda sort of said it. The way I see this is we have something out the door, an idea, a concept, and this is what it is. It's a legislative concept by the 3rd. And given that schedule that Bill showed us, there's a couple more rounds where ODF has input over the course of this year until December, when the final piece of paper one pager goes to the legislature. And I guess I'm committing to, as a board member, being involved in that process as possible, because I think we all care. I think what we've just heard today is we're all very interested in this. We're all very interested in seeing this through. We have to get a concept out right now, and I support the concept, but I think it's been very clear that we all want to continue to be involved in this and make sure the landowner voices are involved in this, to get this right and get this to be something that the legislature will pass. So I'm committing to continuing this work, but I would support the concepts as they are to move them forward.
Carla.
Yeah, I think that's well said. And Brenda, I think you said that well. I think that, I think there's agreement here on the 250 million and on the 61 million. We know continued conversations have to occur, especially on that 61 million. We heard from 4 landowners today pretty loud and clear. But I think we can agree to that concept and move this forward.
Okay, in that case, could I get a new formal motion?
Bill
Okay.
has his hand up. Oh,
Yes, Chair Kelly, if I could add one thing just to manage some expectations on what's expected for the department. So I do understand and hear what's being said. As far as the process, the department already has a placeholder, an official placeholder in play that was due last April, which we did submit, which is very much a blank slate for a legislative concept. On June 3rd, it's expected the department puts forward what's considered its final concept, but that doesn't mean the conversations can't happen. In fact, just next week, we have our initial discussion with the governor's office, which is where we'll share all of this conversation with them so we can influence that process. But as far as the mechanics, the department will submit a concept that it deems moving forward. And the place for a placeholder, I just want to kind of caveat a placeholder moving forward versus the remainder of the process, if that makes any sense. But as far as this input getting into the process, that'll start next week with the governor's office when the department first engages with them.
Thank you, Bill. Brenda.
Yeah, I'm willing to make a new motion if Joe is willing to retract his.
I mean, I guess I mean, first of all, I'm making a motion to support LC1. I'm clear on that. And then LC2, I'm just trying to add for the record, I'm giving, it's imperfect. I'm putting a qualification on that we understand in the record that work will be continued to be done on LC2. I don't know officially what that looks like, or maybe we're all saying the same thing here. Potentially, I just want that in the record.
Yeah, I think we're all saying the same thing, with some of us having more words than others. And I'm sorry if I'm too curt in this whole process.
That's okay. That's fine.
I would second that motion, Joe, if that's a new motion.
Yeah, we'll leave it up to the department to make some appropriate language, but I think the direction here is pretty clear. Our board members agreed. Then we have a motion and a second.
Well, I guess, I'm sorry, Jim, this is McComb. I don't understand what Joe just said. So Joe, if you could just very succinctly clarify your motion regarding LC2, that would be great.
So yeah, my motion is to support LC2 with the understanding that it's imperfect, and the department will continue to work on with stakeholders to perfect this moving forward. Is that succinct enough?
Well, no, I'm sorry. If everybody else votes for this, I'll vote for it too. But I think this is just making a mountain out of a molehill. What we're saying here is that we're going to support moving forward, but we're going to be engaged in discussions, not only with stakeholders, but with others to improve the process and the outcome. So, I don't want to be a problem child here like I usually am, but
I think we're saying the same. I think we're saying the same thing, Brenda. I think we're saying the same thing. I'm just trying to capture that on the record.
All right.
Which I think I've done.
Right. I think you have to. Yeah, it's a little wordy, but it's okay. And my stomach is growling. And Carla, you have officially seconded Joe's motion. Is that correct?
Correct. Yes.
And Brenda, you've retracted your motion?
Oh, sure, I'll retract it.
Okay. In that case, I think we have a motion and a second, and we will vote on this now. And so prepare yourselves, and I will call out board member names. Liz Agpoa.
I vote aye.
All right. Carla Chambers.
Aye.
Ben Doimling.
Aye.
Chandra Ferrari.
Aye.
Joe Justice.
Aye.
Brenda McComb.
I guess.
And I guess I'm an aye as well in that case. And with that, we have reached consensus and the motion carries. Okay. We will move on then to agenda item 5, and that is, as usual for our board meetings, we allow a final moment for any takeaways or thoughts that board members would like to share. Any reflections on today?
I'll start, Jim. I appreciate the conversation. Brenda, I appreciate you and the conversation about this. I mean, this is really important. And I just, thanks for the conversation regarding what we just decided upon the motion we put forward with these two legislative concepts. So that I just thank you.
Okay, Brenda.
Yeah, thanks, Jim. I guess the only thing I would like to say in conclusion for my comments would be, I really hope that future boards of forestry and future people in ODF in the industry can begin to think about fire not as a control and command and control problem to solve, but as something that we need to deal with by accepting the fact that it is there and we need to learn how to live with it. This idea that we're going to suppress every fire, within X number of hours, especially going forward, just seems to me to be living in fantasy land, and we need to find a better solution.
Okay, Chandra.
Thanks, Jim. So I agree this was a good conversation today. And we have a couple follow-up items, including on our first issue, which I'm excited to talk about around consistency. But I did want to harp on the process point just one more time. I know we've kind of belabored this, but I do think that we should have a distinction or a goal to try to make our actual motion language very clear and to the point on what's being requested of us. And then I think it's acceptable, right, to have the conversation and the expectation that's supporting our record on those motion items. And that's come up a couple of times where we have all these things we want to caveat our motions with. And I'm just not even sure how helpful or appropriate it is to have it in a motion as opposed to just our supporting record. And so I just wanted to throw that out there because I'm legitimately curious about it. And I think it's clear for the record to have, the very top line decision points on motions and then have some supporting information that you can dig into in the record to understand why we reached that decision. So anyway, I guess I'm throwing it out there because it's come up a few times for me. And I'm wondering if there is a set of best practices for motions, for instance. And this isn't to harp on anything we did today. I just, I think it's come up a couple of times when we want to add nuance to what we're doing. And I think that's appropriate and part of the record, but maybe not the best for motions sometimes. And now I'll stop, Jim.
Well, I appreciate that you brought that up because it is, this has happened ever since I have been on this board, long before you were. And we sort of stumble all over ourselves and spend a lot of time in some situations in these conversations. And, I keep thinking, and I was thinking it today, okay, it's in the record. There's a record of this meeting. And, don't kid yourselves that staff and the public isn't aware of that. So I agree. I think it would be great to make a real effort not to trip ourselves up in that same way, and let to a degree let that record from our conversations speak for itself. So good advice. I appreciate you bringing it up. Liz?
Yeah, I just a random thought. As we're just leaving this emergency fire discussion, I just am struck on how wildfire, the funding, its impacts, its consequences, just permeate everything, all the plans from HCP that we talked about earlier this month, And I just think it's really important to keep these things cross-pollinated and connected. And I want to just support Brendan, just that we need to think bigger about it. And there's a big piece on adaptive management. And Brenda, at the field trip, we talked a lot about living with smoke and living with wildfire in Central Oregon. So I think that whole conversation is already out in the public, and especially communities that are dealing with this every summer and every season. So that's all I've got.
Yeah, I also want to support what Brenda was saying and what you're saying in terms of this approach of needing to live with fire to a greater degree. And I know from my conversations with Mike and all that he certainly is somebody who understands the benefit of fire and the need at critical times to put out fires aggressively. Both are true. Anyhow, Ben, I see your hand up.
Yeah, thank you all for this great conversation. And I just wanted to echo some of the thoughts that I've heard today, and that I see this as a piece, as a component of a larger effort. And 762 was a big step forwards in primarily mitigation work. This is hopefully a big step forward in the suppression part. And I think this goes again to our tour we had last month. There's a number of different elements that we're all trying to work on at the same time, of reducing the risk of fire, being more resilient, having more resilient landscapes, being able to suppress fire when necessary. And I think the next thing we really need to be working on is how do we restore those lands after the fire. And that's the third part of that three-legged stool. So I see this as a piece. It's not going to solve all of our problems. And it is in some ways a Band-Aid, but suppression is an important tool in the toolkit, but it is only one of the tools.
Okay, thanks, Ben. Carla?
Yep, just a quick comment on, having burned almost 15% of our forests in the last 5+ years. Just that resiliency piece, so we can get back to a natural fire pattern. We're a long ways from that. I hear you, Brenda, but I also heard those firefighters loud and clear on that wildfire council that we let these things go. We can't get them out, which is why we burned 7 communities and lost lives. And we just have a very dangerous situation, for this state, and getting to that resiliency is essential. So I agree, this isn't the solution, but it's a stepping stone.
Okay, I do not see any other hands up. I think very good. Good meeting all. Lots to be thinking about, and lots to do. And with that, this special meeting of the Board of Forestry is adjourned.